Look at that. It's like I didn't even stop and start this video. What are we at now? 17? Well, let's keep on going. My mouth is still working, my brain's still attached. Doesn't always happen. Jurisdiction. Now, you know what? I didn't even go over this paper. I'm just going through it based on how I wrote it, but I bet you there's something we can insert here or there. There always is things to, keep on unpacking, but I think, wow, I think there's no school. I don't care you go to Oxford. I don't know. The elite schools, maybe they teach this. They don't tell this or explain this to the minions. They probably do. But all your other schools that you're not part of the elite school, McGill, or what's another one? California, is that, there I go, UCLA, Stanford, just all the ones for us minions, for citizens. It's a different thing. They're teaching you a certain thing. They don't have to teach you anything else because that's what you signed up for. Just get that. You signed up for it. You paid your course. Considerations had. You agreed to be under trust. That's the rules. Just understand it. And you're only going to be taught based on that level that can go to, because that level has prohibition limitation. It can't commingle with the other. No one's doing anything wrong to you. Jurisdiction. Subject to each level of use to a land interest. We sort of went through that all the way through this whole video series. Main jurisdictions are dominion, territory, and property. Again, we haven't gone to property yet because we haven't unpacked that, but property you can ascertain now that it's under a trust. Territory is what governments have a right to administrate over. Dominion is your right to administrate over the land. It's a separate interest. Land is separate than territory, because territory is the level of use to land, which the level of use to the estate to the land under a legal title, and property is a equitable title which becomes legal under the territorial jurisdictions. Okay, third level. Dominion is held in the monarchy. It's not imagine holding your own in dominion, because you can't hold that. We discussed that. It can never be transferred, but making sure that's secure. That's all it is. That security, that right, holds the preemptive laws to make sure that that's not, we can recognize when that's being overreached. That's what it's held. Okay. And is the primary sub-interest held by each individual when they no longer abstain from exercising their right to vesting their common law interest in an undivided share in land not immediately subject to a trust. Okay? So I was going to digress a little bit with that to, do we need to? But I think we've really got it. But another way of looking at it, if you threw a ball up in the air, and that's of matter, and that's of property, and that's of weight, of mass, okay, it's going to fall to the ground. And you understand its law of gravity. Well, that's the descriptive view, not the explanatory view, and I'm not going to get into that. But you can see a fiction, the air, or whatever else, that the government can't hold that ball any more than the title, the monarchy, or the Pope, or a father, or a citizen. They can't hold that ball because that's a explanation of a duty and power within that dynamic, and it's a fiction. It's like a patent can't hold the ball. UCLA can't hold the ball. These are all constructs. Harry Potter can't hold that ball, and that's when the monarchy holds the land. It's holding the land as the right to hold that land. As each one of those things I discussed have a right to hold that interest. They're holding it for the predominant feature that it secures that the natural law evolution of man. It's holding the right, not the thing itself, but the thing is more or less, melded with the fiction, in as much that they're not separated. So when you talk about it, it means the same thing, but when you're talking about it as fiction, it cannot hold in the relative term, because that's what man is. And you see how that is different again. The only way that you can deal with any of the English law is through a legal personage, because they only hold rights to things for the benefit of whatever that interest hierarchical system is set up on, and whatever level you're in. Okay, territory is a grant originating from the device of free and common soccage that, under patent, gives legal tenure right to the use of a defined area of land, subject to the initial equitable right held by the monarchy, on behalf of class term people who are recognized as the true possessors of holding all land via legal title, which is under law only. So it's only recognized your dominion of a legal title, because English law only administrates over rights to land, so that legal title is only of an interest. You can hold that, but you can never hold it as a dominion, because dominion, you're fully, completely out of English law. But if you want to use English law, use it in as much as using the legal personages to settle that interest till you get your full dominion right. But you always have your dominion right over that right to execute common law or equity. Okay. Property is the only interest a citizen, before immediately subject to the capacity of a tenant for life, can hold a legal title to through purchase under a trust for sale. The first time we were using those words together, I think, under a trust for sale scheme as an assumed owner through the construct of holding possession, now currently moving into the fourth level of use to land, to now be governed exclusively by unnamed trustees who will completely control all property interest as absolute owners. Dominion, territory, and property under English law are each within themselves regulated by law of persons and the law of things. Now, the word dominion can be used in territory, and the word dominion can be used in property. Property can be used, territory can be used in the means of property as well. Dominion, when I'm speaking about, is that was outside of English law, and then you can use dominion, which is the right, like Dominion of Canada back in 1867 when the Constitution was affected, and that gave you dominion rights over that territory. Even though using the same lingo, it means a certain thing because it means something subsequent to that subject matter. So you can interchange these words, and that's why sometimes it's so easy to commingle, because we're always interchanging these words. But if you're speaking to I'm live, and then you're talking to a common law interest, and then you start throwing in equitable rights in the Constitution, well, you just commingle three different things in one sentence. You got to realize when you're speaking to one point, you have to speak to one point. You can't commingle laws, and that reason is for your own benefit, and so that when you're speaking to it, that someone doesn't exercise a power that's subordinate to yours, and has no relative rights to interfere with it. You have the sanctity of that agreement, so if something subordinate cannot come in and usurp that. You can't, without being on the same playing field. So that's one of the benefits. Well, I think I'm going to pause here. I'm going to go into law of persons and law of things, and hope you're enjoying the series so far and doing the best I can, and we'll see what you get out of it. Okay? Until next time, we'll talk soon.